not a member of the tribe. However, there are certain areas where the U.S. Congress has actually given tribal courts jurisdiction, and the main one is child welfare. There's actually a statute that I think it was drafted in the 70s, because there was a major concern that Indian and Native American children were being pulled out of the homes and placed with non-Indians, and that there was going to be a loss of culture. And so they actually legislated that the tribe would be able to take care of their own children. This is where the rubber really hits the road for the counties. There are a couple areas where the tribal courts actually do have jurisdiction over non-tribe members. And the first is called consensual jurisdiction, which is when a non-Indian entity or a non-Indian individual enters into a contract with the tribe for services or whatever it may be, or a residential lease, whatever it may be, and a dispute arises, there is jurisdiction in the tribal courts there. Then the case law has created kind of a broad catch-all saying that a non-Indian's actions on lands within the reservation that threaten or has some direct effect on the political integrity, economic security, or the health or welfare of the tribe may give the tribal court's jurisdiction. Now this is pretty broad language, and the tribes that we've encountered usually hire very aggressive lawyers who are they kind of have an agenda to try to push this exception as far as they can. But we are aware of no federal courts that have actually found jurisdiction over a non-Indian based on this standard. So it's out there. It's certainly being attempted as a way to get jurisdiction over non-Indians, but we've actually never seen it happen. So why does this matter? What are the cases that we're actually seeing in the counties? We've got a couple of different fact patterns for you here. One would be where law enforcement is prosecuting a tribal member for actions off-site of the reservation, and what they'll do is they'll try to sue the judges and the law enforcement in tribal court, and as an intimidation or delay tactic. Another one is we've seen individuals file suit in tribal court because they're unhappy with the result they got in a federal court or a state court. So, for example, we've seen individuals bring civil rights claims in federal court up in Salt Lake City against police officers, and we defend them and we win, and then they go down and refile in tribal court thinking they're going to get a better result. So how do we respond? What should you do if a tribal court action comes across your desk or someone's desk in your county? What you do not want to do is appear in tribal court and go through that whole process. So what typically happens is we will actually, once that comes in, we will file in federal court a separate lawsuit trying to stop the tribal court lawsuit, saying there's absolutely no jurisdiction. This tribal court lawsuit can't proceed against these officers or the judges or whoever it may be. And all we do in tribal court is file a special appearance document saying that we deny jurisdiction, and oh, by the way, tribal court, we've already filed up in federal court, and we're going to fight you in federal court on this. The ultimate goal is to A, win in federal court, but then to get a temporary restraining order and an injunction against the tribal court to stop that prosecution. The bottom line, from the cases that we've been seeing and what the Supreme Court has said is that, states and municipalities have jurisdiction on reservations for off-reservation violations of state law. And so, for example, if a tribal member commits a crime off the reservation and law enforcement needs to go search his or her home or go and serve a warrant or whatever it may be, the Supreme Court has said that that's legitimate and that we can do that. Unfortunately, it oftentimes still results in litigation being brought into tribal court, and we have to go through this whole song and dance. But this is what the Supreme Court has said can be done. So again, here's the number for the UCIP Hotline. Same scenario. It's always just call Jesse up or me or Britton Butterfield and let us know what's going on. We can talk through the process. And we're always happy to look at the complaint or whatever documents we file in tribal court and help. out what the response is. So that's it for me on tribal courts.
Thank you, Noel. And remember your questions. I have one, but we'll wait. Bart Coombs. This is the guy that you'll need for land use. Land use, zoning, subdivisions, everything that people fight us on all times. So.
Right. I think when you said land use, I saw only about 6 of you immediately fall asleep, so we're going to be okay. As he said, subdivisions, building permits, conditional use permits, roads, all sorts of things when I show up at the county. I want to talk to you about 3 issues. One is required by law, so I want to make sure that the county is doing it. The other is one that you should be doing, is best practices. And the last one is just something I'm going to plead with you to please do that will make my life easier when I do show up at your county. So the first is, I want to talk to you about property disposal. It seems strange, but it seems to be a trend right now. There are a lot of challenges going on to real property disposal in the counties. This is under Utah Code section 17-50-312. Under Utah law, when you dispose of real property, you need to dispose of it for what's called present fair market value. And this is where the challenges are coming. They're saying you're not disposing of it for present fair market value. You're paying less, or you're getting less than what it's worth, or you're not getting as much as you can, is how the challenges are often being presented. And what you can get, these kind of plaintiffs are claiming, is the fair market value, because that's what you can get. So this is a source of litigation right now in a lot of counties and municipalities in the state. I'm seeing a trend. So under that statute that I just gave you, the county should have an ordinance governing property disposition. The ordinance needs to specify what a significant parcel is. Leaves it up to the counties. You can describe whatever you want to be significant parcels. A lot of counties say something that's worth, according to assessment value or appraisal, $100,000, $500,000, something like that. Or some of them say something that's larger than 10 acres, or both. All right. However you describe it is up to you, but you need to describe it. And you need to have that in the ordinance saying this is a significant parcel. If it's a significant parcel, the only way the county can sell it is if they give 14 days published notice before they do, and that published notice has to be quote-unquote reasonable. Now again, the statute says whatever the county thinks is reasonable is fine, but it needs to have that in the ordinance as well. And most people say, you know, it's publication in a newspaper general circulation for 14 days prior to disposition. But these are coming up, so I would urge you to please go back, talk to your county attorneys, make sure you have an ordinance on the book, because I recently did a survey around the county, around the state, municipalities and counties. Some of them, if they do have an ordinance, it's not up to snuff. It hasn't been updated, and since this is coming down the pike and rising quite frequently, please take a look, talk to your county attorneys, have them take a look, and make sure the ordinance is updated.
So I tried to bring this up last year, I didn't get much traction. We don't have an ordinance yet, but yeah, the definition of significant parcels varies widely in the
Yes.
state. And some of them are as much as kind of a philosophical definition almost, rather than a dollar or acreage amount. As far as defensibility goes, because I would like to push this, but I want to get us in a good direction.
One of the things that I found surprising in my survey was that some municipalities will say a significant parcel is a parcel that is in public use. Okay, that is a problem though, because there's a very early 20th century case in Utah that says if it's in public use, you can't get rid of it in the first place. All right, so you shouldn't even be selling it if that's your definition of a significant parcel. So that is a huge problem. And a recent, it's a federal case, so it's not controlling, but a recent federal district court case made that exact point and said, if it's in public use, by definition, you can't be getting rid of it under this prior case.
What about caveats as under the definition, you know, where you say it's a certain value or a certain acreage, or the setbacks are not buildable? I mean, in other words, I'd like to draft it in such a way that I can give my legislative body the most flexibility when determining, you know, because we've gone through the process of significant parcel disposal, which is fine, and it's a little bit onerous, but I mean, comparatively, it's not bad. So we generally just opt for the safest route. But I mean, is that okay as far as saying?
I think I've seen it. You wouldn't be the first to define it in an interesting way. I mean, there's some that say if it's next to a certain zone, that's a significant parcel because it's going to affect, because we can anticipate that they're going to ask for a zone change in order to build the same kind of structure on that property as on the zone that's neighboring them. So we're going to consider that a significant parcel. So the definitions vary. I think they're fine. It's up to the discretion of the governmental body. So I don't think you're really going, unless you're completely out there, you're going to be fine.
Okay.
The other thing I want to bring up is conditional use permits. And this is something that isn't formally required by law, but will save you a whole lot of headache down the road if your county does it, and that is to either create a separate document that says these are the conditions of this conditional use permit, and or create just a piece of paper that says it after the vote's been taken and attach it to the conditional use permit so that we know what those conditions are. It's extraordinarily difficult to defend a conditional use permit when all we really have is the transcript, if we've even got that, sometimes we just have the minutes, the transcript of the planning commission meeting. And we have to sort of create, say, this is the motion that was made, this is what passed, so from that you think the conditions of the conditional use permit are these. It will be so much better to defend if you create a list after that vote is taken and say, okay, this is what you voted on, these are the conditions for that permit. Would it be even better if you get them to sign off on it, attach that to the conditional use permit, so that later when that gets challenged, all we have to do is pull out the permit and we have the conditions listed there. There's no question. I mean, we can argue about them, we can argue about everything, but at least we know where we're starting from, which is extraordinarily helpful. The last thing is just my plea, and that is also related to planning commission work. Oftentimes, I come in on a petition for review. This is what happens when someone doesn't like what happened at the planning commission, so they appeal it. And they appeal it oftentimes just to your county commission. Some of you have hearing officers. Counties do it differently. And then they make a decision, and then that goes on a petition for review up to the district court. And the district court sort of sits as an appellate body saying, yes, this was fine, no, this wasn't fine. Oftentimes, the argument is about why the planning commission did what it did, or what it even did, because sometimes all we have are minutes. When you record the planning commission meeting, they have 30 days after that decision to file an appeal. Typically, the ordinances vary, but typically it's 30 days. If you could wait to see if they're going to file an appeal, and if they do, make us a transcript of that hearing, at least a part of it where that vote was taken, that will be so, so helpful in the future. You know it's going to be disputed because they're appealing it. That will become part of the record that the county commission is going to have, and that in turn will become part of the record that I will have when I come in to defend in front of the district court. Very, very helpful. Please do it. That's my take. So, thank you. Just please.
Okay, look, I know it's noon. I know you've been doing a lot, and you're probably hungry, and maybe you want to leave home to go home. But you do have a half hour. These people are here. That you're not going to get this opportunity very often. So, if you think of any questions, here's mine that just came up as I'm sitting here. Noah, and this is probably just personal, but do I have to pay a speeding ticket I get on the reservation?
Gosh, I don't know.
Okay. I'll be calling you.
As long as you don't go back to that reservation.
Good point. And
I
can
want
you
to
give
know
us?
that too, because I got one and I paid it, and I can't, and after that, I learned that you don't, but I'm not positive, so.
Really?
I'd like to know that.
And see, many of us in law enforcement, we feel like the reservation is like Mars. You don't go in there. When you do go in there, you just keep a low profile and go right through. So you say that the U.S. Supreme Court would allow our officers warrant, state court judge can go on the reservation, seize evidence.
Correct.
What about seize people?
I believe that if it's a crime committed off the reservation, I believe that's a subject.
So when they abscond, they go on the reservation, we actually could write warrants and go get them.
I believe so.
Okay, and if I call, can you give us a citation for that?
Yeah, and again, this is, Jesse's much more up to speed on this than I am, so I apologize for laboring a little bit, but I would certainly be happy to answer that question.
I think all of your sheriffs, or most of them, would be interested in this, because I did not know that. We felt like that's a line we can't cross. They go on there, they're free until they come off, and we wait for them. And this opened up a whole new avenue for us.
I actually had a case several years ago that the crime was committed, obviously, in Fox Elder County. The guy fled to the reservation in Navajo reservation. I contacted the Navajo police directly, and he offered to go out and get the guy and bring him to the border of the reservation for extradition purposes.
They must not like him.
Probably not.
Probably not.
I did have a bunch of federal loopholes to jump through because obviously the feds have jurisdiction on the thing, but the Bureau helped me. We got the guy back.
That's awesome. We haven't been that lucky. They told us don't cross, so we don't cross.
But, so our sheriffs can go, because a lot of our gravel piles off of the reservation disappeared one truckload at a time. You know, and we even got one that was using our loader to load it up. So we was told, well, we'll have to wait till we come off the reservation, so they can go on and go get him.
That's my understanding.
I would have a warrant with me, because they can't challenge us. They have every right to challenge us. That's sovereign territory that you're on. So I like the idea of a warrant, though.
Well, and generally, they contact the Navajo police, and the Navajo police meet with
sure.
the sheriff's department.
Oh, yeah.
They go in there as a cooperative effort.
Yeah, you would want their officers there with you, I'm sure of that.
And
But I think it's probably good for liability reasons too. If we're going on there with a state court warrant or order, that's gonna help us out a lot.
And I definitely appreciate that. I think cooperation should be the first approach all the time. And the cases that we're seeing is where this are occurring because there's been a breakdown for some reason. And the county or the municipality and the tribe have gotten sideways on something, or certain individuals gotten sideways and we end up in court. But obviously cooperation with your neighbors is always the best approach.
I think the biggest problem they have is that you call for that cooperation, and then when the sheriff's department can be there within 20 or 30 minutes, and the Navajo police come out of Shiprock, New Mexico.
Right.
So you might wait 4 hours.
Right.
And wait, be good neighbors. Yeah, cooperate. Kristen, when, and you don't have to, if ever, do you think you'll get off the fence on employee evaluations? we debate this. Oh, where is she? Oh, I probably should have saved that. Leanne, our HR director. But see, we're going through that in our county. I do not like him as a county attorney. She has been very good and has pared hers back to simply a 2-category evaluation. And I'm loving that because there's less for the plaintiff's attorneys. But do you see this going one way or the other? I actually copied an article out of one of the news magazines where so many top Fortune 500 companies are going away from employee evaluations.
I'm in favor of documentation, as I've told you. So if they're done right, I would love to have evaluations, because my favorite thing is finding an evaluation that shows that they had the exact same problems that they were ultimately discharged from. That way they had warning. That to me is gold. So if they're done right, I'm absolutely in favor of it.
Now, what if we accept the truism, the fact that they're not going to be done right across the board? Does anyone disagree with that? There are always supervisors. In fact, we could do a whole conference just on supervisor liability. Supervisors, that's where the rubber meets the road. That's where we get hung up in court and get sued. So, is there any way to get around that? I mean, will we ever get supervisors to the point where they're doing it right that you could use?
I think there's some supervisors that do. There are, you know, especially in the comment sections. That's where I think there needs to be more training on. Fill those out, don't be lazy. You know, this is just the little numbers. That doesn't mean anything. But give the comments, that's the crux. That's what we'll look into. And if they'll just fill those out, and that is so helpful. And you know, I don't know if I've had very many cases where the evaluations have been so much in my favor. Most of the time they are better. We go around them. You say, yeah, you may have had this, but what about this and that? So, you know, are they a death sentence? No, like, it's just it'd be really nice if they were done right.
As soon as she goes against performance evaluations, I'm calling her, calling Lee, we're getting rid of them. But I agree with her, personnel files. Every supervisor, well, I guess I could, HR director, should be able to go into a supervisor's office and say, let me see your files. Do you have a file for every employee? Are you keeping track of anything? Of verbals, of teaching moments, of corrective action plans, of discipline? There should be a file on every single employee if you're a supervisor. That's what a supervisor is for. And that's the documentation. The first thing she asks is, where's the file? Show me.
Right. And if the employee asks to get a copy of their own employment file, should you give it to them or not?
No.
Their own.
No.
Why?
We do.
Yeah.
We do. Absolutely. We had it right over.
Just give it to them. Give it to them. Why not? It's their file.
Right.
Okay? There, you can have arguments yes, you can have arguments no. Again, you have nothing to hide in the employment file. It's regarding them. You don't want to be, I've had arguments made that you didn't give me my due process because I didn't have access to my employment file at the appeal hearing. Just give them the file. If it's done right, it's going to support your case. So it's okay.
And if it's done wrong, they're going to get it in.
They're going to get it anyway. So give it to them.
Dale, I've read a couple articles in the human resource newsletters that I get sent on this very issue that what they're seeing in the industry is supervisors aren't documenting when there's a performance issue at the time that there's a performance issue because performance appraisal is 6 months off and they'll deal with it when it's a performance appraisal issue time. That's when they get to sit the employee down and chew them out, is that a performance appraisal. So they put it off, they don't document it, and they forget about it by the time that there's the performance appraisal. So there is a trend, you know, in that profession to go away from the once a year performance appraisal to anytime there's a performance issue, you call them in and appraise that performance issue. So it's an option that county should definitely be looking at.
This is recorded, right?
Mm-hmm.
So I can play this for.
Yeah, I'd be much more in favor of just as issues come up, performance issues rather than a yearly or 6 month. Those to me are meaningless. That's like, okay, I've got to check off my list to get those done. It's when there's something to talk about, do it. That's the most meaningful.
But won't that always be negative then? Or
Yeah.
do you start
No.
doing attaboys?
You do attaboys too.
Oh, yeah.
Absolutely.
Oh, yeah.
There should be more.
Or you're not doing your job as a supervisor. You're not building enough, encouraging them, teaching them, coaching them. You're not doing your job, so that should be in there too. And almost no one, do they ever document attaboys? I don't know if I've seen an attaboy in a while.
Oh, yeah.
Do they? Okay. I think you should, but I haven't
That's
seen
always
it.
plaintiff's exhibit 1, 2, 3, 4, 5.
But we're doing our job.
But yeah, and that's good because that shows that when they're doing something right, we do it. And so it benefits everybody.
One of the best personal issues or experiences I had, and that was, we would talk about goals and document how are we doing on these goals. You know, you set these goals for you, and for your department, for the office, you know, how are we doing? And it was good follow-up because it brought it to my recollection to my supervisor. I mean, in other words, it's not just, you know, the negative.
Right. Yeah.
do annual evaluations because of the merit system. But we also have the ability to do what we call unscheduled evaluations. So if we have issues, whether they're attaboys or, yeah, yes, most of them are probably disciplinary, but we can do unscheduled evaluations using that same template.
And my suggestion to you would be to talk to Leanne, because she scaled hers back to just 2 categories. Oh, yours is 2 only? Love you guys. Okay. The 5 category is 4.5 and then, or 2.5, and then that leads to employees coming in and arguing and then going to commission. Okay, I said no.
Of course, I did have someone become, even with the needs improvement and successful, those are the 2 categories now. I had someone, I wish there was one in between there. Are you serious?
Send them to me. I'm serious. We will have to talk.
And I said, no, it's not happening. This is what it is. So.
Bart, so I was in one of these UCIP land use conferences, and they suggested, and I don't know that we fully implemented, but I want to know your opinion on it, on creating a tiered application review process. What I mean by that is our power plant, our PUDs, we would stick up here in the top tier. That's going to have every due process step, county commission, do the whole thing. But yet, there's got to be some down here that we could just let our zoning administrator do by himself, his review only. Is that okay? Can we get away with that?
Yeah, I think so. I mean, whatever your proposal is, I'm happy to take a look at it, send it my way.
Okay.
I'll take a look at it, but yeah, there are certain approvals that don't need to go through the whole process, and that'll make your citizens appreciate you more, so they don't have to pay for that.
Okay, so
that
they,
costs money for that.
and time. But would they also feel, might they also feel that I'm not getting my fair share because I have a friend on the county commission and they would have seen it differently than the zoning administrator? That's what I'm
But
wondering.
they can always appeal, right?
Yes, they can always appeal.
So I think that they've always had that opportunity, and so if that was their complaint, they would take it up the ladder.
Okay. Okay, we will send it up. I think it would speed things up. We have a new zoning administrator, he's gung ho, and he's on top of things, and I think it would really speed things up. A lot of these things could just go through him.
There are what are called administrative decisions and legislative decisions. So you wouldn't be able to do that with the legislative decisions.
Like zone change.
Yeah, zone changes, no way. But, approvals for some of those improvements, I think, would be fine.
I had a question for Bart. In the sale of property, would that still apply if the county is transferring property to a newly created interlocal or special service district?
Yes, it would, because it is considered a separate entity under the law. And anytime they do a sale, it has to be for present fair market value. There's a case on this. It's the Louder case. It comes out of Iron County years ago. But they were selling a prison to build a new prison. And it's a famous case, but present fair market value has to be.
Interesting. I know that doesn't always happen.
Yes, it doesn't always happen.
It gets sold for $1.
Yeah. There are, it gets kind of nuanced with sort of grants that aren't for profit. But generally speaking, even if it's to another governmental entity, it should be for a present fair market value. At least if you look at that case, that's the way I read it.
Do you know how much these guys charge an hour? We've got 20 more minutes.
I have a
question. For Kristen, unemployment findings. So if you have a termination where the employee files for unemployment, and of course you go through the process of guiding and they go blah, blah, blah. Do you find that if it comes into a court case where you're in an obligation that will play any role whether they were or not?
No, it's not admissible.
Okay, great.
We have fought that battle.
Okay.
And won every time. The only thing that could be used consistently, the decision, the unemployment, if they got it, if they didn't get it, whatever happened there, the ruling, none of that is admissible. The only thing would be if there was a hearing, and there was a transcript of the hearing, somebody's placed under oath, you treat that like a deposition. So if they testified one way in the unemployment hearing, you can use that for cross-examination or whatever in the trial. And we had to do this in my last trial, actually the last couple, where you just say, you don't even say the word unemployment. You say, in a prior hearing or on a prior date, you testified this way, did you not? The jury will never get the unemployment transcript. They won't get the ruling, they won't get the decision. And it's not binding. By law, it is not binding.
Okay, great, that's good to know, thank you.
Good question. Follow up, Kristen.
Yeah.
If our people are testifying at that hearing, their testimony can be used against us.
Everybody.
So consider that.
It's just like the deposition. And what's terrifying is a lot of times these unemployment hearings are done on the phone.
Mm.
Real casual on the phone by an ALJ,
Yeah.
no counsel's present, and they're just spouting off, and they haven't even talked to an attorney ahead of time, and all of that is now recorded, transcribed, and we have to deal with it.
As a county attorney, don't do that.
We always have our attorney at our,
That's good.
Awesome.
on our calls.
Yeah, but talk to your employees before they're,
Before they're a witness.
right,
Okay.
yeah.
I'm not sure if this is much of this, and I talk to him all the time, so.
You talk to me all the
But
time.
for both of us, because I just barely dealt with this issue, that's why I wasn't in here. How, when we have issues with employees, and they come and they talk to me or Dale or whoever they talk to, but then they go to each one of the commissioners and tell their stories too. And the commissioners try and solve the problems. What is the politically correct way, or how can we disinvolve the commissioners in personnel issues?
I've had to deal with that a number of times for a number of counties. And I've had to sit down one-on-one with the commissioner and say, Commissioner, I know you have all of your best intentions, because they are. They're just trying to solve the problem. But there is a chain of command. And if you have people skip this chain of command, so many problems and protections can be waived and avoided, etc. Plus, Commissioner, you may be getting yourself involved personally, where then later you're named personally and you're in that same position that that sheriff or the supervisor is in. And so I know it's difficult politically. Sometimes you gotta go to someone like Johnny, or you gotta go to someone like me or any of my colleagues here that can sit down and say, look, I am completely disinterested in this, but let me tell you why this is not a smart idea for both you and the county and the employee. They may think that it is, but it's not.
The other problem that I've seen with that one is that ultimately the commission's gonna hear appeals, right?
Yeah.
In a quasi-judicial basis. And so then the employee says, wait a minute, I talked to two of those commissioners about this, they can't make a decision on this.
Right.
So that's the really good one for the commissioners is, and the employee, you cannot talk to the commissioners, because at some point, you may be in a hearing in front of them. So you can't talk to them about this issue until you're in that hearing. Would that be correct?
Absolutely, and you want that commission to be as unbiased as possible to give them a fair shake. And yeah, it just creates so many problems and so much distrust. It usurps authority of the sheriff or the supervisor or whoever it is, and it's a mess. And they're just doing it out of good intentions, but
And it's the same thing for Bart's issues with the conditional use permits and stuff, that those people shouldn't be going to the commissioners talking to them, because the commissioners will be hearing it later as a quasi-judicial
Right,
body.
it usually causes some sort of claim of bias and that they didn't go through process on their fellow bodies, so.
Are we saying that commissioners need training?
commissioners and supervisors
Yes.
and sheriffs.
Usually if you tell the commission that they're gonna be the appellate body, they'll back off. Or you say, if you screw this up, we're gonna have to hire an ALJ, and that's gonna cost thousands of dollars to do the hearing or whatever. They'll back up. In small towns, it is hard, because they catch them at the grocery store, go to their house. Commissioners, yeah, probably the source of most of our problems after the show.
Okay, so here's my question. If there is a lawsuit or the chance of a lawsuit or something going on, the person who wants to sue the county is going to sue the county, they have an attorney. Their attorney calls my office and start asking questions. Do they need to identify themselves?
I wouldn't talk to anybody who doesn't want to identify themselves. And if you've got a lawyer or your employee contacting you and asking you questions, I would say, look, your counsel, I need to have my counsel and go to your county attorney. Absolutely.
But if they are doing something deceptive, you let us know.
Oh, yeah.
There are ethical rules, believe it or not. Attorneys have ethical rules. Book, and I think that's unethical myself. May depend on where they are in the litigation, but I would definitely go after them. The next phone call would be me calling their office saying, what do you think you're doing? But be careful. If someone's asking weird questions, wrong questions, you have every right to say, you know what, I'll get back to you. And then call them.
And if employees, attorneys demand to be present at ladder mill hearings or disciplinary hearings or meetings, you don't have to allow it.
And, land use is a different beast, but my instruction is typically once the lawsuit is imminent or has been filed, I ask the county attorney that all communications go through the county attorney regarding the suit. So if they can get a call and you determine that someone related to the suit, just forward them off to the county attorney's office.
And if you're in a lawsuit, make sure you talk to your employees about